The pandemic has been brutal throughout all of America. If you are interested in the employment lawsuits that I've seen during the pandemic, please watch the next video, which is From Hire to Fire, Employment Practices and Best Practices as it relates to employees and employers. Thank you. Hello, my name is Paul Cheng and I'm back. I know previously we did a small lecture on wrongful termination, and I have another section related to employment law called Hire to Fire. And really, I give this lecture to many of my clients as well as businesses across Southern California in regard to from hiring an employee all the way to firing an employee. What are the best practices that are available to the employer, and the best practices when an employee feels wrong, they can be able to speak to an attorney about. Now, best practices in and of itself is not, I repeat, it's not really a legal term. The term really is about how an employer and employee relationship should be, apart from the law. And I'm going to explain to you how if you use best practices in your own business, you'll be able to do things in a much better way. And in many times, it's going to be in a very legal way. Let's talk about hire to fire, because in California, there are over 7 million legal cases that are filed on a yearly basis. And why is that important to you? Because in all of America, there's only 350,000 federal cases that are filed on a yearly basis. So in California, there are a lot of cases that are being filed. And I guess the question ultimately would be, well, how many of those are actually employment cases? And those are half of the cases out of the over 7 million cases that are filed on a yearly basis are employment cases. And employment cases are inherently very difficult. Employment cases, in my opinion, are no different than family law cases. Why? Because employees as well as employers spend the best part of their day in the business. So basically what you do after you work is you go home, maybe spend 2 to 3 hours, watch a little bit of TV, watch news, and you go to bed. You don't spend that much quality time with your family, and that's a reality. Well, employees feel in many ways that they've given their best part of their day to the employer. Well, the employer is the same way. The employer also feels that they've given the best of their day to their employee. I remember when I first started, over 15 years ago, I didn't have any business, meaning that I didn't have any clients. I remember one of the first employees that I had, I was so happy and I wanted to treat her so well. And as I continued to grow and I had more employees, I would have to go out and I'd buy dinner for them. And they would always ask me, well, aren't you hungry? I'd say, I'm not hungry. The reality of the situation is I didn't have any money for dinner. So all I could afford was to buy food for my employees. And when my employees didn't look and the food they didn't finish, I would pack it up in a to-go box and I would eat it as an employer. Well, why do I share that with you? I share that with you because in employment cases, both sides feel hurt. Both sides feel wronged. And therefore, employment lawsuits are very contentious. Again, no different than family law cases. But let's get back to the topic of hire to fire. And what that means is, what are going to be the best practices from the inception of someone that's hired all the way to the termination of their relationship, which in my opinion, what I call to be fire, and it's really because it just rhymes, so it's a hire to fire issue. When you hire an employee, it's actually a very simple process, but here's the problem. In California, there's something called the California Wage Theft Act. And what that means is under Labor Code 2810.5, 2810.5, there are certain requirements that are given to the employee that the employer must do. One of them is going to be a written notice that provides the rate of pay, allowances, if any. For example, if there are any meal or lodging allowances, some employees have that. The regular rate of pay that needs to be provided to the employee. If the employer is doing any doing business as, so if they do business in a different name, you also have to provide that as well. The physical address of the employer must be given to the employee. The telephone number of the employer must be given to the employee. The workers' compensation carrier, this is very important in that a lot of employees are miscategorized, and we're going to talk about miscategorization, but a lot of employees are miscategorized, and so one of the requirements under Labor Code 2810.5 is that you provide your workers' compensation insurance over to the employee. In addition, there's also sick leave information that you're provided to the employee as well. Now, why is that important? It's important because a lot of employers in California, small or large, are not complying with Labor Code 2810. And because they're not in compliance with 2810.5, I apologize, what ends up happening is that the employee will end up suing. There may be injunctive relief that occurs. And in California, when an employee sues an employer, they're able to get attorney fees and costs if they win. An employer, on the other hand, is unable to get attorney fees and costs if they win. As a general rule, what they would have to do is they'd have to have a second lawsuit to sue the employee to show that the employee had some type of malice. So in regard to the inception of the employment relationship, you must comply with Labor Code 2810.5. Now, earlier we talked about the independent contractor and employee relationship. So in California, there's really going to be two main types, categories of workers. One is going to be a regular employee, and a regular employee is subdivided into whether you're exempt or non-exempt employee, and we're going to talk about that. The next issue becomes whether they're an independent contractor. So an independent contractor, as kind of a general rule, is able to control their hours, when they come to work, what they do. It's more based upon contract work. So a lot of times if you hire somebody, for example, to build your roof, if you hire somebody for a specific project, that's going to be an independent contractor. However, in California, after AB 5 and a lot of the rules that ended up passing, the independent contractor relationship is very difficult to have. And so there are two things that I want to share. If you are confused whether you should categorize an employee as an independent contractor, you can just basically Google it online, DE38, Delta Echo 38. And what that's going to do is it's going to give you the information and the different factors that are necessary to determine whether your worker is an independent contractor or whether they're an employee. The second issue is something called DE542, Delta Echo 542. And what is that? DE542 is a form that you file with the state of California. And you file that form with the state of California if you pay an independent contractor over $600. $600. Now, why is that important to you? Because we represent both employers and employees. We've done many different types of cases. In misclassification cases, typically the plaintiff will ask the employer, please give me your DE542. And you know what the employer is going to say? I don't even know what a DE542 is. And so it's very important that you speak not only to your HR or your accountant. Many of them don't know about DE542 because they know about federal taxes, but they don't know about state taxes that well. But a DE542 is required as a matter of law so that if you have an independent contractor, when you hire them, you can legally be able to do it. Now, that doesn't mean that if you look at DE38 or DE542 and you file it correctly, they're automatically an independent contractor. It's very important that you categorize correctly. So important that if you intend to hire independent contractors, I do recommend that you speak with an attorney so they can be able to categorize your workers correctly, because most of your workers are going to be regular employees and not independent contractors. Now, one of the wonderful things about coming to America is that opening up a company, super easy. super easy. It's very hard if I wanted to open up a company in China or in Europe. They have a lot of requirements. In the United States, instant, quick. The problem is this: if you're coming to the United States and you're trying to get US citizenship and you end up owing your employees money, or if you end up miscategorizing your employee as an independent contractor, there are statutes out there that make it a misdemeanor. And if you have a crime, you have to explain to immigration that no, I really didn't have any ill intent. But in my opinion, if you're trying to get your US citizenship, why miscategorize your employees? Now, I do want to say this. I do understand why employers and employees may want to be independent contractors, because on both sides, you technically don't have to pay any taxes. The employer doesn't pay any taxes, and the worker, the independent contractor, can assess their tax and almost eliminate their taxes. Because really on a payroll, it's almost 1/3 of an employer's pay is going to taxes, and almost in many ways 10 to 15, 20% of an employee's wage also goes to the state of California. But unfortunately, what ends up happening is that when an employer says, but the employee wanted me to pay them in cash, the employee didn't want taxes, the employee essentially wanted to be an independent contractor and get benefits from the government. That occurs all the time. But unfortunately, when there's a termination of the relationship, the employee will always say that they were forced to be an independent contractor, they didn't want to be an independent contractor, and therefore the employer will lose. Now, in terms of paying part check and part cash, does that happen? That happens all the time. We have many restaurants, even mainstream restaurants, that pay half check and half cash, and they do it because the employee requests it. My recommendation is to document all of that information. My recommendation is to not avoid the situation, because in the event of a dispute, your documentation is going to control. Now, in terms of the independent contractor relationship and the employee relationship, there are two main types related to wage and hour. Now, we're going to talk about other issues in terms of best practices, but in terms of the employee relationship, there are essentially two types of employees. One are going to be exempt employees, and the other type are going to be non-exempt employees. Exempt employees are going to be paid at minimum 2 times minimum wage, and they're really going to be in a managerial or in a high administrative position, or they're going to be a professional. And when I say a professional, I'll start off with the last one. It's very easy. They're usually licensed. So attorneys, doctors, CPAs, those that are licensed and are paid 2 times minimum wage, they are allowed to be exempt. And what exempt means is no meal breaks, no rest breaks, no overtime. However, a majority of the employees are going to be non-exempt employees. And what's a non-exempt employee? A non-exempt employee is going to get overtime. They're going to get overtime in 2 different ways. One is going to be a daily overtime rate, and there's also a weekly overtime rate. A daily overtime rate is if you work over 8 hours a day, you're going to get overtime. And a weekly overtime rate is that if you work over 40 hours in a week, you also can get overtime as well. The calculations for them are different, and I do recommend that if you have an employee that works over 8 hours a day and over 40 hours a week, that you speak with an attorney, not a CPA, because they do not quite understand the overtime rules and regulations, but what you need to do is make sure that it's categorized correctly. There are other forms of overtime as well. If you work 7 days in a week, there's another form of overtime. But the 2 main types of overtime that you're going to see is a daily overtime rate and a weekly overtime rate. In terms of meal breaks, for every 5 hours, you're going to get a half-hour meal break. And for rest breaks, you're going to get around 3.5 to 4 hours. You can get a 10-minute rest breaks. Now, in terms of a rest break in California, there's California law that says rest breaks aren't necessarily required. They can be provided, but if not specifically given, it's okay. But again, that's going to be the general rule. But the meal break law is a law that a lot of employers get sued over, in that for every, again, 5 hours, you're going to be giving a 30-minute meal break. Now, in terms of a meal break violation, there is an exception. So in California, the law is that if an employee works 6 hours and under, they can be able to have a meal break waiver. Now, again, earlier I said that at 5 hours, it triggers a 30-minute uninterrupted meal break. But if they work between a 5 and a 6 hour shift and they stop at the 6 hour, they can actually waive their meal break if it's written. Now, why is that important to you? It's important to you because most restaurants are going to be open approximately 12 hours. So what a restaurant employer, and really any employer, can do is they can have 2 6-hour shifts. And so they can have a total of 12 hours that the restaurant is open. In each shift, the workers essentially can be able to waive their meal breaks. Now, in terms of a compassionate way to be able to do it, what most employers do is allow employees to be able to eat essentially on the job. But in a situation like that, it's totally okay. Why? Because it's 6 hours and under, they can waive their meal break rights. Your meal break rights occur every 5 hours, and therefore, if the employee essentially works between 5 to 6 hours, they can be able to waive it if they execute a written document. Now, can an employee be able to waive all of their meal breaks? And the answer is no. So if an employee essentially triggers a second meal break, but they waive their first meal break, they cannot waive their second meal break. In terms of meal break, there's actually something very interesting in the state of California, and it really applies to restaurants. So if you notice there are a lot of restaurants, what I've noticed is a lot of Japanese food restaurants are closed. They're closed between, let's say, 1 to 4, 2 to 4, 2 to 5. In that situation, it's called a split shift. And on a split shift, what ends up happening is that an employee that is off for more than 1 hour, that has 2 shifts, essentially as a general rule, are paid an extra hour of pay. So I'm gonna say that again, it's very scary. Is that an employee that is off for more than 1 hour, for purposes of a business that's closed, they need to get paid an extra hour because it's a split shift. Now there's a calculation for that, and that relates to whether they're getting paid minimum wage or above, but it's very important to speak to an attorney if you have a split shift issue. Now, going back to the exempt and non-exempt, I do want to say that if an employer pays 2 times minimum wage, that doesn't make somebody exempt. So I'll give you an example. Let's say a person comes in and every single day they are taking out the trash, and they get paid super well to do that. They get paid $15,000 a month. Very, very good pay for taking out the trash on a daily basis. If they are not in a professional, managerial, or high administrative position, you still got to pay them overtime. So it's a very extreme issue. Now, how do you calculate overtime? It's actually a very simple process. Essentially, if you are above 8 hours a day, it's just 1.5 times. And what attorneys typically do is they take an annual salary, they divide it by 2, and in many ways that's going to be your average rate of pay. Now, getting back to hire to fire, I find a big problem, and that is the internet. The internet has a lot of good information and a lot of inaccurate information. And one of the inaccurate informations that I see are employee handbooks. Now, what does that mean? An employee handbook in the state of California are able to reflect California law. They're not able to reduce California law, meaning that you can't be able to say, I can sexually harass you because my employee handbook said so. I don't give you meal breaks because my employee handbook says so. That's different than in other countries. And this is a problem that I face with employers that come from other countries, because in many ways, their employee handbook is almost like a contract. And if an employee signs an employee handbook, then they're bound by the terms of the employee handbook. An employee handbook in California is not required. In fact, I completely recommend to my employers that if you're unfamiliar with an employee handbook, you don't even need to have one. It's not a California requirement. However, there is case law, lots of case law that's out there, that basically says that if your employee handbook given to an employee gives additional benefits than what California gives, then you have to follow your employee handbook when there is a dispute, and you can be sued over your employee handbook if you don't comply with your employee handbook when it is in conflict with California law because it gives you additional benefits. So I'm going to give you an example. In California, there is no requirement that you pay anybody overtime for any national holiday, and we get that all the time, particularly in restaurants. An employee will say, tomorrow's New Year's. Chinese restaurants are open all the time on New Year's. That's kind of the funny thing about LA, right? If you have a lot of friends, they'll tell you, particular races, particular religions, they'll tell you they love Chinese food on New Year's and on national holidays. Why? Because only Chinese restaurants are open. Well, the Chinese employee will say, you need to pay me overtime because I'm working on New Year's, I'm working on Christmas, and there's no California law that allows it. The problem is that if you download an employee handbook, and the employee handbook says all employees that work on all national holidays are paid overtime, guess what? In a dispute, you have to pay overtime, even though California law does not require it. And this is a very serious issue because a lot of employers, because they want to do it right, end up doing it wrong, because they end up pulling from the internet, changing the names a little bit, and basically giving benefits that California law does not require. My goal is that every employer do things in accordance with California law. If you do that right, the employee is going to be very happy because California has more benefits than any other state in the nation. But what ends up happening is that the employer ends up promising something that's not in accordance with California law. You can't default to California law in that regard. So I'll give you another example if I haven't made it clear, is that if your minimum pay in your office, for example, is $30 an hour, and in a situation like that, you can't be able to say, well, the default minimum wage in California is much less than that. You have to default to $30 an hour. In terms of hiring an employee, earlier I talked about independent contractor, employee relationship, exempt, non-exempt. One of the things I forgot to talk about is workers' compensation. Workers' compensation in California is a California requirement. And independent contractors are not required to have workers' compensation insurance. One of the problems that I've been seeing with many of the employers is that they're so trusting of their insurance agent, they'll buy whatever insurance is out there. Well, here's the problem, is that many insurance agents are not providing workers' compensation. Now, you would say, how does that happen? Many businesses buy business liability insurance. That's a very common insurance. And many employers believe that a commercial insurance or a third-party insurance is going to protect them for workers' compensation. Those are totally different insurance. So a commercial insurance typically is for third-party injury. Somebody walks into my law office, they fall down on the ground, and they get injured. That's not workers' compensation. And so there are many employers that have purchased other insurance unrelated to workers' compensation. Workers' compensation in California is fairly, for all the insurance out there, fairly inexpensive for new business. So it is very important that you buy workers' compensation. If you have independent contractors and you're a little bit confused about whether you should buy workers' compensation or not, speak to your insurance agents. There are actually insurance for workers' compensation that's out there that would also encompass the workers' compensation for independent contractors. So you really should think about that and speak to your insurance agent before you make a decision not to purchase it. So you really should buy workers' compensation. Failure to buy workers' compensation can lead to criminal action against you. And again, I've said earlier that if you are a foreigner coming to the United States, you don't have to be a US citizen to open up a company. We'll have plenty of lectures on opening up a company in California, S corporation, C corporation, LLCs, etc. But because it's so easy for you as an employer to open up a business in California, it's very important for you to buy adequate insurance. Now, since we're talking about insurance, I'm not an insurance agent. But what I do say is not all insurance are equal. And what does that mean? If you are purchasing an insurance, don't base it on the price. And unfortunately, because the insurance agents in general are very competitive, you may be confused because you don't understand the value. So what you do is just base it on price. So if an insurance agent comes to you and says, well, every employee you need to pay $1,000, but I can sell it to you for $800, you have to look at what is being covered. Because for a little bit more money, the workers' compensation may cover many more important issues that you may not think about. In California, because we're a very litigious state, I really recommend that you look at, definitely you should be looking at different insurance that are out there. And if you are a high asset individual, you should be looking at what's called umbrella insurance. Umbrella insurance. And umbrella insurance basically covers many more issues that regular insurance, commercial insurance, workers' compensation does not cover, but you should consider getting that as well. So in an employment case, when it comes to me, I typically say that there are two main types of cases that come to me. Things that are outside. Outside, I would say, are going to be wage claims. And things that are inside. And what are inside? Inside are things that you can't see. Discrimination is a huge one. Harassment is another one. Those are all cases in California, and in some ways that happen on the inside. Now you have to understand, although we have many clients that speak English very well and we handle a lot of mainstream clients, we do have a lot of clients that English isn't their first language. We have people that speak Spanish, we have people that speak Chinese, people that speak Korean, and so that's the way I kind of explain things. Now, things on the inside, because it's hard to see, I always tell the employer this: what would the most ideal employer do in a situation that's presented? So if an employee comes up to you, for example, and says, hey, Tim's been harassing me, would the ideal employer look at Sarah and say, well, Sarah, Tim's 70 years old. He's not harassing anybody. If he could harass somebody, you should be happy, Sarah. You should feel lucky. No, the most ideal employer wouldn't do that. Now, the reason why I use that example is because it happens all the time. An employee will come up to you and will say something that you may feel is completely ridiculous. It doesn't make any sense. How could that happen? Well, in a situation like that, you should always ask yourself not to be subjective, but to be objective. And to be objective, I always tell the employer, it doesn't matter how you feel, just ask yourself, what would the ideal employer do in a situation? If you go under that direction, 99% of your actions are going to be correct. Now, earlier I talked about you need to hire an attorney to do categorization of your workers correctly. I'm not saying that you shouldn't hire a law firm, but many times your HR, as well as a business owner, many times they're making on-the-job decisions. Somebody comes up to you and they say, I feel uncomfortable. I don't like Tim. I don't like Bob. I don't like Joe. And in situations like that, you have to make snap calls. In a snap call, my reaction is that I would always recommend to the employer to do what the ideal employer would do in your head. And if you do that, you will find many of your actions are going to be in compliance with the law. Now, here's a problem that employers frequently encounter, which I completely understand, and that is a lack of documentation. You don't like an employee doing something, and you feel very uncomfortable about the employee doing something. That is very common. And so what an employer will do is they'll typically verbalize their complaints, their concerns, over to the employee, and hopefully the employee will be able to correct it. But when there is a dispute, what ends up happening is that the employee will have a story, totally understandable, and an employer will have a story, totally understandable. But the problem is in California, because you are going to face a jury, usually, jurors are typically employees. They're not employers. They don't understand that employers struggle with not wanting to embarrass somebody, not wanting to write somebody up. But unfortunately, California, you're really going to need to do that. Now, in terms of writing a person up, this is the big question. Many people feel that if you write somebody up, you have to let the employee know. California law does not require that in any way. If you have a concern with an employee, document it. If you have a problem with that employee, write it down. Even if it's an internal memo between you and HR. It's not a California requirement to give the employee notice that you have a written warning against the employee. In fact, many jurors have said to me that they're very concerned that if the employer had a problem with the employee, that they never documented it at all. Juries in California are a funny bunch, and it has nothing to do with them being employees, it's a fact. A juror, although they are not required to in any way be prejudiced, in many ways they are prejudiced. They aren't able to understand that hiring employees is very difficult. They aren't able to understand my story of going out and buying food for my employees and not being able to eat dinner and eating their leftovers. They can't understand that. And because of that, you have to be able to run your business as if you're going to be presenting your case not to employers, but to employees. And there's nothing wrong with that. That's a fact of litigating in California and really all across the world. If there's any opportunity to be in front of a jury is going to perceive life as if they're an employee. They're going to think things are reasonable based upon their perception of what's right or what's wrong. And it's not necessarily a prejudice, it's just how they feel. So in terms of the things that are inside, there are, again, discrimination, and there's going to be harassment, retaliation, failure to accommodate, a lot of those issues. My recommendation has always been you can hire an outside law firm to do the investigation for you. It's not expensive at all. Now, why would you have a law firm be able to do that for you? So you can be able to lean on the law firm to be able to say that you made an objective investigation over a complaint that happened at work and you complied with the recommendations that are given. Typically what happens is that an employee that goes through an investigation never considers it to be reasonable. They always say that HR is going to stand on behalf of the company because HR is hired by the company. They're not really sitting in the middle. And so what many companies have done, and I think wisely, has hired law firms to be able to come in to do the investigation and to be able to make the determinations and the findings of fact and to be able to give recommendations. Now, here's the problem when you hire a law firm to come in. Tim, that you really like, the law firm could make the conclusion that Tim did sexually harass somebody or that Tim retaliated against somebody. In a situation like that, if the law firm recommends that Tim needs to be terminated and you don't terminate, that could be a very serious issue. And hence why many employers don't want to hire outside law firms. Because if a law firm comes in and they're hired to make the determination and the investigation and you don't follow it, that could be a very serious issue. Lack of an investigation, I think, is what drives many employees to go see lawyers like me. What ends up happening is that there are very few times that I've spoken to an employee, and again, I work on a lot of employer cases, but I do see employees that come in, right? If we're overbooked and the attorneys are busy that work on the employee cases, I will meet with the employee cases. All the employees, 99% of them, have always said the same thing. I don't want to meet with an attorney. I don't like meeting with an attorney. Apart from a car accident, workers' compensation, and maybe a divorce, maybe immigration, I never thought I would be in a law office, but my employer has done nothing. My employer has not done the investigation, therefore I'm here. And of course, what is the attorney going to say? I don't know if the employer did the investigation. We have to sue and we have to find out. And so it's very important not only that you do an investigation, that you do what an ideal employer would do, but you also notify the employee as to the status of the investigation. Let them be part of it. I think you'll find, earlier I used the example, I believe, of Sarah and Tim. I don't necessarily think if Sarah has a problem with Tim, she wants Tim to be fired. She wants Tim to be demoted. It's very rare that that ends up happening. What Sarah really wants is she just wants an investigation to be done, and she wants Tim to improve. And I think that if you as an employer are willing to do those steps that are necessary, you will find that Sarah is not going to go out and sue, because what will end up happening, for example, is the law firm comes in, let's say they make the determination, we can't conclusively say yes or no that Tim sexually harassed Sarah. You go up to Sarah, you say, Sarah, the law firm made a determination that Tim, we can't really tell yes or no, but you know what? We're gonna send Tim to a sexual harassment class. We know that everybody does sexual harassment classes, but he's gonna do an extra one. And we're gonna separate you and Tim. Sarah, you can work whatever shift you want, and Tim will work on the opposite shift. Are you okay with that? 99% of times, Sarah will say, okay. She'll sign on the dotted line and she'll say, I find that to be acceptable. And isn't that what you want as an employer? Is that although there's a lot of frustration that goes into place, yes, there's a lot of manpower and money that's necessary to do the reasonable investigation. In terms of the reasonable investigation, once that's conducted, you'll find typically that Sarah is very amenable, very calm, very relaxed. What ends up happening, again, just to repeat myself on purpose, is that a company does not do either an investigation, or they do a little investigation, or they do an investigation, they don't involve Sarah. And so Sarah is just left in the dark. And that's where I think many companies make the mistake in terms of the investigation process as it relates to employment disputes. Now, let's talk about the last portion, and that is hire to fire. Let's talk about the fire portion. Now, the fire portion really is an issue, although I use hire to fire, it's really any type of termination of the employment relationship. That could be that the employee quits, that could be that the employee resigns, that could be that the employee just walks out, that could be where the employee is actually terminated. Now, here's the question that I have for an employer when you want to terminate an employee. California is an at-will state, and what does that mean? An employer can terminate an employee for any reason as long as it's not illegal. So whenever you hear the word at-will and you're kind of confused, now you know. So I'll give you an example. Let's just say I'm wearing one of my favorite clients, right? Sriracha it's a great company and I love them. I'm wearing the Sriracha socks. I don't know if you can be able to see. They have really good socks over at Sriracha. So it's red, it's blue, and it's green. It's got bottles stretched across my socks so my feet are big. Let's say the employer comes up to me and says, I don't like your socks. I don't like Sriracha. I don't like red. As stupid as that sounds, that's totally okay in California. Totally okay in California. What's not okay is to say, you know what, this white handkerchief, only Asian people wear white handkerchiefs, or only gay people wear white handkerchiefs, or only this, or only that. Therefore, I'm going to terminate you. That's obviously illegal. That's obviously going to be an illegal termination. But in terms of a termination, we have to revisit the issue. Is if there is a dispute, are you going before a bunch of employers that understand at will, or are you going to be going in front of employees that really don't understand what at will means? So when an employer comes to me and they say, I would like to terminate somebody, I don't ask them, are they at will or not at will? Do they have a contract or not? Are they independent contractor or not? I always ask them the question that every juror is going to ask. Why? Why are you going to terminate this employee? Tell me why. And if the employer has a reason, I always ask, do you have documentation to substantiate that termination? So I'll give you an example. Many employers, rightfully so, don't like employees being late. Why? Because employees that are late, it's kind of like a cancer. Don't mean to use a very extreme word, but attorneys say that all the time, is it spreads. It spreads all over if you don't take care of it. Because one person says, well, if that person can do it, why can't I do it? Right? Why is it okay for Sarah to be late, but Tim can't be late? Is that discrimination? Is that a problem? So Tim's gonna be late. So now Sarah and Tim is late. And next thing you know, everybody's late. So employers are frequently struggling with people being late. Well, here's the question I have. If Sarah has been repeatedly late, can you be able to document for me that you have either told her, or you can be able to document that it's occurring all the time? And can you be able to document that she's the most extreme case? Because what ends up happening is that an employer provides a justification, but when the employer is sued, the justification falls. So I'll give you an example. I used an example of Sarah and Tim. Sarah's always late, and Sarah is fired, and the reason is because she's late. And then we ask, or the plaintiff, Sarah, asks for all of the time records of the employees. And guess what? Sarah is not the most late. In fact, on a scale of 1 to 10, Sarah's like a 5. Tim's been copying her, but Tim's really late every day. Sarah's late twice a week, but your rationale for firing Sarah is now extremely weak, because it looks like you're discriminating against Sarah, you're retaliating against Sarah because of her protected class. In California, there are so many protections. We have more protections than any other state. We have protections on our hair, we have protections on our gender, we have protections on our sexual orientation. Many states don't have all the protections that we have. And so that's the reason why I always ask the employer, why? The first question is, why? The second issue is, do you have documentation to substantiate your why? Now, the employer will typically tell me, well, I've been struggling for 6 months, a year, 2 years. I always say to the employer, welcome to the club. I've struggled too. I have had poor employees too. Even at a law firm, I've had employees that I have not been happy with either. But you know what? An employer typically is holding it within their tummy, and it just blows out sometimes 6 months, a year and a half later. But unfortunately, during the time when you have had problems with this employee, you have not documented it. And I basically tell the employer, if the employee really is this bad, if they're really that bad, then they're going to continue to be bad, and you can start documenting it and give it about 6 months and let's revisit the issue. If the employer says, you know what, I really can't, is there any other way you can be able to do, and this is not a legal document, but it's really what attorneys have done. It's called a performance improvement plan, and many companies out there call it essentially a PIP, a PIP. And so on a PIP, what you do is you identify the issues, you write down all the problems, you provide any documentation that you have or really don't have, and you identify to the employees the problems that are there to allow the employee to improve. Let's just use the example of Sarah again. Let's just say Sarah is late. She's not a 10 every day. She's not a 1, meaning that she's on time every single day. She's late 2 to 3 times a week. And she's been like that for, let's say, 6 months or a year. Your performance improvement plan would be able to say, Sarah, here's a problem that I have with you. You're late every single day, or you're late 2 to 3 times a week, and it's causing a lot of friction and problems at work. I need you to be able to improve on this situation, or there's going to be adverse consequences to your employment relationship. Let's just say Sarah does a 180 and she totally changes. Aren't you happy as an employer? Aren't you happy? But let's just say that Sarah now says, you know what? Screw you. I don't care. I'm going to be late even more. Well, in a situation like that, what do you have? you have the documentation that's necessary to be able to justify the why. So once there is a dispute, you could be able to present that objective documentation over to your attorney as well as plaintiff's counsel so that they can be able to litigate the case properly. Now, today I've spoken on both sides. I've spoken both on plaintiff side and defense side. And I think actually that's what makes our firm really good. We do obviously a lot of good areas of law. I personally do business, real estate, and labor. Those are my three best areas. We have other areas of law that other attorneys handle. But my last recommendation is this. If you are an employee, because lack of documentation also exists on employee side as well. Typically, employees aren't looking to sue. They're just looking for a change or an investigation or some type of response. Write it down, send it to your employer. There is nothing wrong with doing that. I know it's scary. It's scary for the employee. It's scary, just as scary for the employer. But you know what? If you give an opportunity to your employer to make that change, I think that 80% of employers that are out there, one, probably didn't realize it was a problem, and two, even for purposes of trying to avoid litigation, want to be able to resolve the matter with you. Because ultimately, we're not looking in California for more employment cases. I mean, yes, a law firm is run on cases that come in, but my hope overall is that in our short life, 36,000 days, I probably have 10,000 days left, not that many days left, that we live in peace, because ultimately both sides are working hard, particularly during COVID. COVID has been so difficult. It's caused a lot of tension. And people aren't interacting with each other. Everybody has become so explosive, whether you're an employer or employee. If you're an employee, you have a problem at work, the best thing for you to do, in my opinion, is to write that letter. Write down your problems. Allow the employer to have corrective action. Allow the employer to even disagree with you, because at least you know you're being heard. From the employer standpoint, if you do receive something from an employee, don't ignore it. Even if you think the employee is ridiculous, right? I hear that all the time. Employee's ridiculous. How could they feel that way? Right? We take them out to dinner. We treat them so well. We're not violating the law. Well, you know what? If an employee sends you a concern and you try your best to resolve it, please do it in writing. Please involve the employee, because I think ultimately, just like a marriage, I'm going to go back to marriage, is that employment disputes are no different, and in some ways even worse than divorces. And to avoid a nasty divorce, in my opinion, the best thing to do is to communicate, to be able to be open, to be able to improve, and hopefully be able to have that business that you've always wanted, to create a business that you want to work and where your employees want to work. Thank you very much for your time.